Start. On 18/3/2004, an incident took place by which the son of the claimant, who allegedly was a rider, was killed in a road accident. Stop. The Motor Accident Claims Tribunal, after examining the evidence, came to the conclusion that the accident was taken place due to the rash and negligent driving of respondent, who was the owner of the motor vehicle and who was driving the aforesaid motor vehicle. Stop. The victim was aged 28 years. Stop. Coming to the conclusion that a salary of rupees 3000 per month would be adequate. Stop. The MACT finally held the insurance company liable to pay a total of rupees 2 lakhs plus 6% interest thereon. Stop. In the appeal filed before the High Court of Uttarakhand by the impugned order dated 28/12/2016, the High Court held that since the insurance company denied that the deceased was only a rider and stated that he was in fact driving the vehicle himself, and since respondent number 2, who ought to have been called as he was the only surviving eyewitness, not being called as a witness, therefore proved fatal to the claim, as a result of which the petition under section 163A of the Motor Vehicles Act 1988 would have to be dismissed. Stop para. Further, the High Court also held that nothing was brought on record to show that the deceased was having a valid driving license. Stop. In this view of the matter, the appeal was allowed and the judgment passed by the MACT was set aside. Stop. Shri N.K. Shahu, learned counsel appearing on behalf of the petitioner, has argued that the petition being filed under section 163A, it is clear that the liability is no fault, as a result of which it is not necessary to prove the negligence or any rash and negligent driving on the part of the driving of the vehicle. Stop. He further argued that the multiplier is ex facie incorrect, since it was taken on the basis of the claimant's age and not the victim's age, stating that since the victim was only 28 years old, the multiplier should have been maximum. Stop. He also argued that the High Court was wrong in placing the burden on the claimant when MACT has held that based on the examination and cross examination of the claimant, the facts could be elicited. Stop. Further, the validity of the driving license under issues numbers 2 and 3 was given up by the insurance company but taken into account by the High Court. Stop. Sri A.R. Jain, learned counsel appearing on behalf of the insurance company, reiterated the High Court's judgment and further argued that no fault liability under section 163A is limited to rupees 1 lakh. Stop para. At the relevant time, therefore, even if we were to uphold the MACT's judgment, the maximum that can be awarded on the facts of this case is rupees 1 lakh. Stop. Having heard learned counsel for the parties, we may only extract the order of the MACT. Stop. It has again been proved that the deceased was the rider and another one was driving the vehicle at the time of accident in a rash and negligent manner, due to which he received grievous injuries which resulted into his death on the spot. Stop. It will be relevant to mention here that no controverting evidence on this issue or on the issue number 2 has been adduced by any of the opposite party, though they have made the pleadings otherwise in their written statement. Hence, it has not been proved on record by any of the opposite parties that at the time of the accident the deceased was driving the vehicle. Stop.